Zealand. It's my pleasure to welcome you here tonight. Fertility New Zealand is a registered charity, and we are dedicated to providing information, support and advocacy for New Zealanders facing any kind of fertility challenge. We help Kiwis grow whānau in whatever way that we can. So without further ado, I'm going to introduce our speaker for tonight. He will give a presentation of between 20 and 30 minutes. If you have any questions, please feel free to just type them into the chat box, and Stewart will answer them at the end of the presentation. So I'm very pleased tonight to introduce to you Stewart Dalley. He is Barrister and Solicitor at Ryken and Associates in Auckland. He specialises in the law around this kind of area and has helped many people. So thank you very much, Stewart, and over to you.
Thanks, Nicola. So yeah, I was just looking just before I started, and I looked at the number of slides I had, and I thought 20 minutes, okay, so I better crack on to this as quick as possible. So legal aspects of donation and surrogacy. The outline for tonight is I'm going to cover what the ECART approval process is and what's involved in it, and some stats around ECART, because I know quite a lot of people have dread when they know their application is going to ECART. Then donations and surrogacy, what you can pay for in relation to that. And then laws relating to advertising around surrogacy and donations. Then what parental rights and liabilities come from donor and surrogacy situations. Then talk a bit about adoptions for surrogacy and parental leave, and then the heart register. Okay. So first, donations. So most donations, as it says there, don't need ECART approval. If you use a clinic recruited donor or donations between friends or acquaintances, family members, and sperm donations or egg donations, then those things don't necessarily need ECART approval. But ECART approval is required where it's an embryo donation or using donated eggs in conjunction with donated sperm, and then in some family scenarios. But you'll be told, obviously, by the clinic if you're actually going to require ECART approval. In terms of the next slide, which is domestic surrogacy, then ECART approval is required for gestational surrogacies. It's not required for a traditional surrogacy because a traditional surrogacy under the legislation is an established procedure. But as I say there, the process for the clinics mainly is to still refer them to ECART anyway. But it's worth noting there, as probably everybody's aware, commercial surrogacy is illegal in New Zealand. Therefore, you cannot pay somebody to be a surrogate. Obviously, that differs if you're overseas. So, what is the process? This is assuming it's an ECART process. Then there's medical reports will be conducted for all the people involved in it. So the donor and the recipient parents. Social work involvement is required if it's a surrogacy situation, because ECART want to know that the adoption that's going to have to occur later on is likely to be supported by Rama Tamariki. So that forms part of the ECART process, because what they don't want to do is approve an application and then baby's due to be born, and then we find out that actually Irama Tamariki is never going to approve the adoption, and then it's, well, what's going to happen to this child? So that's why they require early involvement of Irama Tamariki. So then individual, joint and group counselling sessions are held. I know, from some people they say, oh, counselling, they really need to go through that. But then when I end up speaking to people after it, they always say that they got quite a lot out of it and it was really helpful and it was a good forum to talk about issues that you might not necessarily want to speak about. So it's certainly a useful process. Independent legal advice is required for all parties. So that would be that if it's a surrogate, then it would be the surrogate and her partner would need to get independent legal advice, and the recipient intended parents would also get legal advice, and those reports are added together with all the medical reports, and then everything is shipped off to ECART, who meet 6 times a year. And the ECART approval is required, obviously, before the clinic will do the procedure, and then an adoption would follow after the child is born if it's a surrogacy situation. So, as I say, ECART's not needed for everything, but certainly my view, and I think a lot of the clinics share the view, is that even if you're not having to go through ECART, you're better to mirror the ECART process as much as possible. And certainly from a clinic's perspective, they want you to use the clinics because they feel you use the clinic and then everybody's had the clinic counselling sessions and everybody's had independent legal advice, then if things were to go badly, at least there's some protection there. So it's mirror that process as much as possible. I'm seeing quite a lot of people who want to actually co-parent the child. So, traditionally applications that go to ECART or what have come to clinics have been, a couple want to have a child or a single person wanting to have a child and using donations or a surrogate. But now what we're seeing a bit of is, say, for instance, a single woman and a single man who are friends but not in a relationship together, but they actually decided they want to co-parent a child. So the woman's going to give birth to the child using the donated sperm of the man, but the man wants to be an active part of that child's life and co-parent the child. So in those situations, again, it's better to mirror the ECART process by everybody getting independent legal advice and everybody having counselling as well, and then having a memorandum of understanding between the parties as to what it is they're actually intending to do here. The point of that is that if it was to go wrong at the end, then one party would be able to try and challenge it to the court to get the court to give effect to what they intended from the beginning. There was a recent case in Australia whereby you had a lesbian couple and a single man, and the man had donated the sperm for the child, but had always intended to be part of that child's life, and he was part of the child's life for many years, and then the couple decided that they wanted to move from Australia and come back to New Zealand, and the man challenged that to the courts in Australia, and the courts looked at the situation and looked and said, well, this was never a strict donor situation. This person always intended to have an active part in the child's life and did have an active part in the child's life, and therefore he is an active parent of the child and gave effect to what they had originally agreed, which prevented the couple from moving from Australia back to New Zealand without his consent. So, it's important that you cross your T's and dot your I's and get some agreements and go through the clinic process in order to safeguard for the future, because everybody can go into these things with the best of intentions, but sometimes things fall apart. So ECART, it fills a lot of people with dread, but I think it's actually unwarranted when you look at the stats. So last year's ECART, in terms of surrogacy, you see there was 28 applications, 19 approved, 7 deferred, and only 2 declined. And the reasons for the decline were, health risks to the birth mother and child, which couldn't be mitigated. The deferrals it required specialist medical reports, or there was some medical information that was missing. And then in one situation, there was a question mark about the orangutan Mariki's approval for the adoption. Comparing that to 2017 figures, 20 approved, 9 deferred. So the themes there, whereas the vast majority, I would say, are approved. And then when they're not, they're deferred, get us the medical report, and then we'll approve it later. You see there, 1 was subsequently approved, of those declined. And then in terms of donations, 16 approved, 7 deferred, 3 declined. Of the 3 that was declined, 1 was later approved. So again, for the similar reasons, there's lack of medical information, or there was some medical parts. There's a lot of buffering happening for me, isn't there, streaming? Voices in and out, apparently, I'm reading here. I don't know what we can do with that. Nicola, are you seeing this? People are saying that it's voices cutting in and out. Is that happening at your end too?
It sounds perfectly fine from my end, but I wonder if you might try turning your speakers down completely and see if that makes any difference.
I have done so. I've muted my speakers, so we'll keep going. And obviously, if people are still experiencing these problems, then please message through. So, just to sum up that last slide there, the ECART process. Sorry, I've skipped one there. Is that the vast majority of cases it's going to get through. What you need to ensure within the key to success is good medical reports. If the specialist medical reports are required, making sure that they're there, rather than it going in and being deferred and having to come back again, and that you get counselling done and legal reports are all squared off, and that they cover everything that needs to be covered. So, a question that's often asked of me is, what can I pay for? What am I not allowed to pay for? And the Act that says, as I've laid out there, basically it's a crime to give or receive valuable consideration for the supply of human embryos, or to participate in a surrogacy. The Adoption Act also makes it an offence to give or receive payments or rewards for somebody to enter into an adoption. You can read for yourself what the punishments actually are. But the HART does not apply to international surrogacies or donations, because I think people might be thinking to themselves, well, if that says that, then how can you do an international surrogacy or international donations? Well, it's because New Zealand law doesn't apply to the other country, and therefore, as long as it's lawful in the country that you do it, then there won't be any issues here. As I say there, what ECART wants to see on an application to it is an assurance that the recipients or the intended parents are going to pay for life, disability, and income protection insurance for surrogates, and they don't consider that to be valuable consideration. I think really what valuable consideration is perceived to be as a chunk of money. Say, if you act as a surrogate for me, I will pay you $30,000. That would be considered illegal. And obviously, if caught, you could be fined $100,000 or sent to prison. Yeah, somebody's saying the sound still keeps cutting in and out. I don't really know what we can do about it. I mean, I think that this is being recorded, so if the issue is that it's cutting in and out for you, it might be that the better thing to do would be if after this event and it's posted back up, that you could watch it again, and then I would assume that the cutting in and out wouldn't be there. Have there been any prosecutions in relation to this? No, none that I'm aware of. There was also an issue for one point there where a lot of people were putting their names on birth certificates when they shouldn't. And again, nobody had been prosecuted for that, despite it being an offence. So advertising is like another linked thing. So the Heart Act says it's illegal to advertise for others to take part in prohibited matters. So there's a list of things that are prohibited under the Heart Act, which, but a surrogacy that's altruistic or a donation of human embryo is not a prohibited matter. So therefore, you could, if you wanted to, advertise and say, I am looking for a surrogate. It's illegal under the Adoption Act to publish an advert indicating that any person desires to adopt a child. So that would be saying, I want to adopt a child, I'm looking, whereas in a surrogacy, you do have to adopt a child, but you wouldn't be saying, I'm looking to adopt a child, you're saying, I'm looking for somebody to act as a surrogate. So therefore you wouldn't run foul of the law. As I mentioned there, and you'll all be aware of big cases where people have went on television, have done documentaries, or they've appeared on the Sunday show and things like that, and talk about their fertility journey and problems that they've been experiencing and how they're looking for a surrogate or somebody to donate embryo. Those people have continued, they've in some instances got surrogates, they've went to court, they've adopted the child, and nobody's batted an eyelid at it. And the reason being is because it's not prohibited what they're doing. And anyway, probably being interviewed on the Sunday show wouldn't be considered to be advertising in the strictest of sense. The strictest of sense. So parental rights. So, you know, who are the parents of a child in these situations? Well, the Status of the Children Act says whoever gives birth to the child is the mother of the child. The birth mother's partner, whether that's a woman or a man, is the other parent of the child. And an egg donor or a sperm donor have no parental status. So that also means that if, for instance, an embryo is to be created using a man's sperm and then a donated egg from somebody, and then that's to be put in a surrogate, despite the fact that that person who's provided the sperm and wants to be as the intended parent, he's still considered a donor. The law doesn't recognise his intention, it just says you're a donor. I mean, the reality behind this is the way that the Status of the Children Act was developed was to make sure that real donors do not have any liability in respect of children that they help create, as a way to encourage people to be donors. Whereas they felt that if you were going to be liable for this child, then there's less likelihood that you would actually act as a donor. There's still work to be done around the Status of the Children Act, because it doesn't really mirror what's happening in society now. So there is need of reform there. And I know that some people are looking at it, but I think it's more tinkering around the edges, and we'll see what actually transpires. So again, it's birth mother and her partner, if she has one, needs to register the birth with their details. So, the birth mother's on it as mother, her partner's on it either as mother or as father of the child. The person who's provided the embryo isn't on it, or the intended parents aren't on it. But obviously you could register the birth and pick the name that's going to go on that birth certificate. It could carry your surname. So as the donors cannot, or intended parents cannot go on the birth certificate. It's an offence in itself, but again, nobody's been prosecuted for it. So adoptions, this applies in surrogacy situations only. So you need the adoption to transfer that legal parental status, because, as I say, the birth mother and her partner are considered the parents of the child. So an adoption can take place in New Zealand regardless of the gender. So two women or two men, or a woman and a man, or a single man or a single woman can adopt a child, either jointly or on your own, and it doesn't matter whether you're gay, bi, trans, hetero, or whatever. The law doesn't discriminate in this regard. There is only one part of it whereby it says that a single man may not adopt a female child unless there are special circumstances. And one of those special circumstances is that you're the biological parent of the child. So if, for instance, you had a single man who used a surrogate to have a baby and used his own sperm, then he wouldn't be prohibited from adopting that child. The birth mother needs to consent to the adoption as well as her partner, and that can only be done 12 days following the actual birth of the child. You need social worker approval to have the child in your home immediately following the birth. So this is part of that pre-assessment process. So, if you're doing the ECART, that's going to be done. If you're doing it DIY at home, then you need to make sure that you contact Rama Tamariki and let them know of this impending birth, so that they can look at assessing you prior to the child being born. So, with that pre-assessment process in mind, then from there on, the formal process is filing the adoption application along with the consent. Then the court notifies Rama Tamariki to complete a report. So if they've already done part of it, then really what they're doing after the court's told them to write the report is coming to visit you at the home with the child and see everything's okay, and then you complete the report. Then that gets sent back to the court, and the lawyer needs to file written legal submissions about why the adoption should occur, and there's some paperwork along with that, and then the court hearing typically takes place about 3 to 6 months from filing. The app was cutting out, but the laptop's great quality apparently. So yeah, the court hearing about 3 or 6 months really just depends on what court you're nearest to, and how busy that court actually is will dictate the hearing time as to when you get it. Then the hearing, the day of the hearing, it's the adoptive parents and child need to go along with their lawyer. It's usually a 15 to 30-minute hearing. It's the only nice thing that family court judges do. So it's quite a nice thing. Usually the judge will have a bit of a yarn with you and have a chat and find out about you and the child and what the circumstances are. Despite the fact they've got it in writing, they just like to have a chat with you. And then usually in surrogacy situations, it's a final order that's made at first instance rather than an interim, followed by more reviews and then a final adoption. They just move straight to a final adoption. And that'll be granted on the day, and we get a picture with the judge for the family album. And then the court notifies the Department of Internal Affairs, and then so, a few days or a week or so after the adoption hearing, you can phone up and get a birth certificate. Then that birth certificate will show you and your partner, or you and your own, as the parent of the child. So say it's a single woman who's used a surrogate to have a baby, then following the adoption, it will just have that single woman's name on the birth certificate as mother of the child, and there will be no father. If it's two men, then it will be father and father. If it's two women, it will be mother and mother. If it's a man and a woman, then it will be mother and father. You have the option of having an adoptive parent or not. The vast majority of people do not have adoptive parents. And I think that the reality being in a surrogacy situation is because they don't really see themselves as adoptive parents. I know myself, as somebody who's adopted children following surrogacy, I don't see myself as an adoptive parent in the traditional sense. So, we didn't plump for that. So following the adoption and the birth certificate happening, then the child is a New Zealand citizen. If one of the parents was a New Zealand citizen or resident at the time of birth, or the visa status follows that of the adopted parents. But really, that's more for international surrogacy. And domestic surrogacy, the surrogate's going to be a New Zealander anyway, so it means that child was a New Zealand citizen at birth, and the adoption's not going to change that. But if it's an international surrogacy, then, say for instance it was international surrogacy and the child was born in the US, then the child was a US citizen at birth, and then following the adoption, then the child would be eligible to be considered to be a New Zealand citizen, but only if one of the parents was a resident. It sounds like my neighbours are letting off fireworks. I notice I'm at 28 minutes into this, and I've still got about 2 slides to go. So parental leave and pay is, again, it's something that comes up quite a lot, and especially in a surrogacy situation. So it's, well, what am I entitled to and what's the surrogate entitled to? Well, both of you are entitled to paid parental leave, assuming you meet the criteria of being in employment for the required amount of time. I know that there's some people who don't know what that is. They don't believe it's actually true, but I've personally confirmed it with the Department of Internal Inland Revenue and MBIE, who operate these policies. So the surrogate is entitled to paid parental leave, as is the adoptive parents. Yeah, and so make sure that you claim for it, and you're both entitled to the full 22 weeks. Again, assuming you meet the criteria for it. Donor register. So there is a register held. There used to be a voluntary register. Now there's a mandatory register when it goes through the clinics. So the clinics need to notify the DIA, who's the holder of the heart register, on the birth of donor conceived children, and they need to tell them the donor's name, address, date, place of birth, child's name, gender, date, place of birth, and the guardian's name and address. But the clinics hold a lot more information as detailed there, and so the clinic really is the one that holds most of the information. The DIA has got some skeletal information. So donors can ask for the name of any child born from a donation, but the child has to be 18 and consent personally to this information being provided to the donor. But the donor can get access to, a child has been born using your sperm or whatever, and they would be informed about that. Contact with a donor can be requested and not reasonably refused. So it's really, it can only be refused if, and information can only be refused to be shared with people when it's likely to endanger another person. And the clear advice is that you would to use fertility clinic counsellors to help with donor linking. And if you want to actually meet the donor, with your child, say the child's come to an age and they want to know and they want to meet this person, it's probably best handled through the clinic and using their counsellors, because unless you've already got an established relationship with this person, then it could be traumatic, or needs a wee bit of finessing, better than what I can do. So that's really it in terms of the presentation. I know I'm over time, but there we are. So I know that was a kind of whirlwind through things, and hopefully the sound wasn't too bad for people, but it's now time to cut over to questions. So let me look here what I've got. We're in a TS process and spoke to Mariki, who said we are not able to get the social work approval doc because we're not going through a clinic. Is this your understanding too? No. That's not the case. Basically, a Mariki, you complete an application form to adopt that a Mariki must provide to you. And there's a whole pack there. So there's an application form, there's reference letters there from for friends and family. You need to do medical checks, you need to provide police records, and then a Mariki would then interview you to do a pre-assessment. Look, if they're not willing to do it, a lot of the time you end up with a duty social worker when you phone the Mariki, who may not actually know what they're talking about. So it pays to ask to speak to a supervisor, to the manager. And if you're still not getting anywhere, then maybe you need to call Ghostbusters. Speak to myself or somebody else and see if we can assist you in navigating the process. Sometimes, it's just individuals. I know that when we went through it ourselves, we were faced with, a lot of rubbish when we went through it. So I'm not surprised to hear it, but persevere, ask for them to send you the pack. And if they refuse, then ask to speak to the manager, or if that still doesn't resolve it, then get a lawyer to do it. Okay, I'm just having a look here to see if there's any other questions. Okay. Will this be available after the stream online? Yes. Let me see. Sorry, I'm just scrolling through this. I'm seeing one here, but for some reason it's really faint. So it's my partner and I have a son who was conceived using donated egg. We were matched with our donor through a clinic and met before starting the process, which is something we all wanted. I've heard it's different for sperm donation in that sperm donors have less say about meeting potential recipients. Is that right? Well, I mean, I guess it'll really depend on the clinic's own policies and how they do things, but certainly I think if you want to meet them and it's part of the process, then it could be facilitated. I don't think MD would prohibit it. And then, you know, if the person if you can't meet the person, then you're not sure about whether you want to use their sperm, and the person refuses to meet, then I guess it's something that may factor in whether you want to use that person or not. But I think it'll depend on the clinic effectively. That's what I'm saying. Okay, I don't know if we have any other questions or if people are mid-typing. Let me see. If intended parents and surrogates are all New Zealand citizens, but the process IVF is done overseas, is valuable consideration still a legal issue? So I guess what the question is if you had intended parents and you took a surrogate with you to the US, for instance, to do the IVF process for one reason or another, you didn't want to use a New Zealand clinic, would valuable consideration still apply? Well, it's a good question, and I'm trying to think of the answer off the top of my head. But the thing is, where the child was conceived and where the process was done, yeah, I'd really like to think about that one a bit more, because I wouldn't want to give the wrong advice about this. So whoever has asked the question is probably better email me at that email address and I can have a look at it for you further, because I don't want to just say something and then it turns. I'd rather think about it, is what I'm saying, in a really bad way. Can you see changes within the current term of this government in terms of law change? No. I believe Louisa Wall was looking at a bill in relation to surrogacy, and there was some talk in there of, instead of having an adoption, that you would have a parental order. There's issues with that, and because currently New Zealand doesn't recognise a parental order issued in any other country. So my concern would be that there may be an unintended consequence from us changing to that. It would mean that we'd have to recognise other people's ones, and it would mean that other people would need to recognise ours. But you'd need to have all of these agreements put in place, whereas as adoptions are internationally recognised and have been for 100-odd years. So it's not just as simple as that, and I'm aware that there was a petition put into Parliament around changing the adoption laws and also these things as well. And the Adoption Act needs overhauled. There was a case that I was part of that went to the Human Rights Review Tribunal, and it held that there was 7 aspects of the Adoption Act that were inconsistent with New Zealand's human rights laws. So that in itself tells you that it needs to be revamped. But that court case took place somewhere in the region of about 5 years ago. So yeah, I wouldn't hold your breath. Do I know or have any idea how many donor conceived children are on the list? I do know, but I don't know right now. I have the information, but I don't have it with me, because I actually, along with some representatives of Fertility New Zealand and counsellors from the clinics, met with the Registrar General to discuss the heart register recently. because we feel that it's coming to the time. This heart register came into place in 2005. So, you do the math and you say to yourself, it will very soon, donor conceived children will be hitting 18 and may want to be accessing this information, may want to be doing some donor linking themselves. And with the advent of online DNA matching and what have you, they need to be up their game a bit. So, we're talking to them about how that can be better facilitated. But again, as to your specific question, how many people, I can't remember off the top of my head, but it doesn't include people who have donated, who have done DIY donations or DIY surrogacies. It's not there because that information is not kept by the clinics, because you never use the clinic, and therefore it's not shared with DIA. We have been told by OT that they would not do a home visit for pre-approval adoption until a pregnancy is established. Is this your understanding? Have you seen such an OT will visit approved OTs before going into surrogacy situation? They won't do a home visit, but they may get you to come and visit them in their Ramatamariki office. But generally speaking, if it's an ECART process, they have to do it before the child's conceived. But if it's a DIY process, then they would probably wait until until a pregnancy was confirmed. So basically 12 weeks on was when they would actually get involved. So in those situations, you really need to do an honest assessment yourself and say, well, do I have medical issues that would prevent somebody from approving my adoption? Do I have criminal convictions which may prevent me from being assessed to be a suitable person to adopt? Do I have horrendous financial situation which may cause people to pause as to whether you would be able to adopt? Do I have a long history with Ramatamariki or other previous incarnates, which would maybe cause somebody to question whether they would approve you? But if none of those things apply to you, then it's a situation where you say, well, okay, we're moving ahead with a surrogacy, and Ramatamariki will then do their thing after 12 weeks. But again, it goes back to what I was saying earlier about this is why people are encouraged to use clinics and not do it DIY, because you don't have the same safeguards there. It's a bit more risky. It's not to say people haven't done it, and people had to do it in the past in certain situations because ECART wouldn't approve their situation because of you couldn't adopt or whatever. But now ECART can approve most things. So, the encouragement is to use the clinic. Obviously, that comes at a cost in some situations. So, it can put people off. But in short, the answer is 12 weeks after if it's a DIY. If it's not DIY and it's through a clinic, then they will do it earlier. Okay, any other questions here? It does not look like it. Well, there's somebody, one coming through. Thank you. It's more of a statement, but thank you, Stephen, as well.
Thank you very much, Stewart. That was an incredibly helpful session. For anybody who had trouble with the audio, it may have to do with your bandwidth, so hopefully the recording will be okay for you. Just before we close off, if you haven't already heard of the Donor Conception and Surrogacy Network, please, we welcome you to join it. It's a community for anybody considering or who has built their whānau through donor conception or surrogacy, to provide guidance and discussion. So please search in Facebook groups. So I would like to close off tonight just by saying thank you very much to everybody who's joined in, and especially to Stewart Dalley. And you can see his contact details are here. I'm sure he'd be happy to hear from you. So thank you very much for your time and your expertise, Stewart.
Thanks again, everybody. And then, as Nicola says, if you want to get in contact, then just use those details there, and I'm happy to answer some questions.
Thank you very much. Hey, Kunera. Good night.